Thank you everyone for being here. Good afternoon. This is the fourth and last lecture in the series on international law and the making and breaking of hegemony of the Amsterdam Center for International Law. I am here replacing Dr. Andrea Leiter, who has too many things going on, and it falls on me to introduce our speaker today. I am going to do this by memory, but let's hope that it works. Professor Andrew Lang is a professor of international law and possibly a fancier title at the University of Edinburgh, and has just been elected a co-editor-in-chief of the Journal of International Economic Law. And is a colleague that we have been ever since I've been in the field. He's one of the most has done some of the most percussive analysis, has a fantastic power of synthesis, and he was previously in many other institutions that I think we don't need to go over all of them, but he wrote one of the formative books for me, which was International Trade Law After Neoliberalism, some time ago, and has a book coming out anytime soon. But as someone who has had the book coming out anytime soon for many, many years, I know that this is not something that is always straightforward. And I think today talk is, can I have the title again? The final title? Or?
Oh, wait, no, it's not.
Okay.
I've forgotten the title.
Exactly. So he had a more official sounding title that you can on our website, but he, as academics sometimes do, has making market infrastructures. Yes, and then as academics sometimes do, he has been tinkering with that, and he will then tell you more about where he arrived at.
Okay, so thanks, Geraldo, and thanks to Andrea and to Ingo for everything you guys have done to bring me here to the Amsterdam Center for International Law, and thanks everyone for coming along. So Andrea suggested it might be useful if I speak for around 40-45 minutes. So I'll do that, and that will still give us plenty of lots of times to just discuss whatever you want to, really, whether it's some of the themes here or something else. And so let me begin. So I start looking backwards. So the last 4 decades, since the mid-80s, we've witnessed an extraordinary historical experiment in the making and remaking of global markets. And in significant part, that was a legal project. Global markets were made using legal technologies and through legal practices, and international law played a central role in that. International lawyers, as Philip Alston wrote so memorably 3 decades ago, we have served as handmaidens to that project. And I think I can say our field, international law, but particularly international economic law, was radically transformed as a field of expertise and practice, emerging in its present form as an instrument of and an accompaniment to economic globalization, but also as a site of contestation over it. So those last 4 decades provide an incredibly rich and illuminating historical record for investigating the general question of how markets and economic orders more generally are legally constituted, and the more specific question of how international law is involved in those processes. And so I want here today, the point of this talk is really to look at those 4 decades, to just take another look at them, with a view to understanding better the processes by which global markets were legally constituted. Obviously, it's a very narrow window onto that, but that's the large question. And my argument will be, first, that this was a period marked by a radical disenchantment of economic governance, and I'm going to explain that term in a moment. And one of the consequences of that disenchantment was that the process of constructing legal infrastructures for global markets was carried out in distinctive ways through the mobilization of technical expertise about the design of market institutions, through the internationalization of administrative procedure to discipline the emergent regulatory state, and third, importantly, also by creating an environment in which legal infrastructures of markets themselves, market institutions, were themselves made subject to processes of ongoing reform and competitive contestation. In other words, that's part of the dynamic by which they were made. And at the end, I get to a point where I argue that we need a re-enchantment of economic governance as a necessary part of an adequate response to the current moment. And so that's the argument in a nutshell. And I can imagine one response immediately would be to say, why do we need to look backwards now, historically, just at the moment when that post-Cold War international economic order seems to be collapsing all about us? Do we really need another historical account of that order? Why don't we talk about the new order which is emerging? Is what I'm going to say only of historical significance. Well, I hope it'll be clear by the end that I'm offering this argument as an intervention into contemporary debates about what's happening now. And what I'm trying to show is that the contemporary rupture we're living through, and we are living through a rupture. This is not a story of just simple continuity, though, of course, it's both continuity and rupture. But we're not just living through a rupture, a reaction to the old neoliberal order and its dismantling. We're also living through a working out of that order's pathologies. That's the argument I want to make. And I'm going to suggest that one of the legacies of those 4 decades has been to leave us, international lawyers, with an impoverished set of tools and vocabularies for responding to the present moment. And I think understanding that legacy is the first stage of building a new one. Right, so that was the introductory bit. Let's start the argument fully. So I start with the contentious term of neoliberalism. And if I were asked to summarize just in a couple of paragraphs, one of the most prevalent explanations of what happened in the 1980s and 1990s and 2000s to produce economic globalization, it would go something like this. Right, key series of shocks, starting from the Nixon shock in the early 1970s, oil crises of the 1970s and 1980s, debt crises in the developing world in the early 1980s. And that period, that decade of shocks, was the start of a profound change to the post-World War II international economic order, in part as a result of those shocks and the economic instabilities they set in train. You get a new set of political ideas about the role of the state in relation to the market. This was the neoliberal free market revolution, most visible in the West in the political programs of Thatcher and Reagan. And it ushered in a profound change to the modes of economic governance associated with the post-World War II social welfare state. So this is a story of the crumbling of the post-World War II social welfare state and the embryonic emergence of the regulatory state. And that transition, to use Timothy Mitchell's formulation, moves from governance of the economy, turns into governance of the market. And the first and primary aim of government in relation to economic life comes to be to establish the conditions for free and fair competition as widely and as comprehensively as reasonably possible. So the Cold War ends, the unipolar period of US hegemony begins, and the stage is set for the global dissemination of this set of ideas known as the Washington Consensus. And the international order, the international legal order, institutional order is marshaled in the service of that project. And that means the use of international law to remove barriers to trade, to facilitate flows of investment, to remove restrictions on flows of international capital. It means international development institutions reorient their work somewhat, focus more on the creation of market institutions in the developing world, and their integration of the developing world into global economic flows. Okay, so that's the story, in some respects, the background again, for which I want to tell my story. So I don't think all of us would tell exactly that story about how we got here, but I think it will be a recognizable story pretty much to everyone in the room, I think. That's my phone, sorry. I think it's been a hugely influential story in public debate, but also in shaping our analyses in international law. It's been central, I think, to a diverse stream of critical international legal scholarship, which has taken issue with the way that international law has been an instrument of that project, supported it, legitimated it, and operationalized it. That story has been the starting point of some of what I've written before. But the story I want to tell today is a little bit different. It starts in the same place, in the sense that I want, in the sense that I think whatever happened during the 80s and 90s and 2000s, this period of legally constructing global markets, it's intimately connected to the emergence of neoliberalism. It's not only a product of neoliberalism, but I do want to make the claim that we can't really understand it properly unless we take seriously its neoliberal character. That said, for this purpose, I start with a slightly different understanding or definition of neoliberalism than I think that story does. And I don't want to spend an hour leading us through the complex debates about what neoliberalism is. Of course, it has many faces. Of course, it's internally contradictory. We probably should understand it in different ways for different purposes. And so this is just a story. But I would draw out just 2 or 3 points from the literature which are seminal for me. One, this is a body of thinking and political practice which proceeds from the premise that competitive orders, markets, are not natural but are made. Competitive markets in neoliberal thinking need a strong and disciplined state administering a framework of institutions of rules to actively maintain them. The first half of the 20th century, with its combination of widespread monopolistic abuses on one side, revolutionary reactions on the other, had made this clear to the neoliberals. And this meant that it was the proper task of a strong government to establish that legal and institutional frame for markets necessary to bring into being a truly competitive order. Now, in fact, I would argue, and this now is my voice, not theirs, I would argue for an even more thoroughgoing denaturalization of competitive ordering than this. So for me, it's not just that a legal framework creates the space for a free expression of our natural tendencies to compete, which I think there are many different positions within a broader neoliberal school, but I think that would be a summary of what a neoliberal position would be. Instead, following Donald Mackenzie and others, I see the neoliberal practice of making markets as involving a fundamentally more constitutive processes, making market subjects, making competitive subjects, constituting the stakes of competition, establishing the terms of competition, making available certain competitive strategies, disabling others. In other words, neoliberal market making should be understood as a form of discipline which works politically in part through the construction and mobilization of competitive ordering at multiple scales. Okay, so that's the first thing the first leg of my understanding of neoliberalism. The second one is this: we need to understand what neoliberalism was against. And here I turn to William Davies, who describes neoliberalism as being haunted by the spectre of the planner. And what was it about the planner which provoked such a reaction? Well, partly it was the hubris of the self-confident technocrat. And as Hayek most famously made clear, much neoliberal thought is predicated upon a deep skepticism of the claims to expert knowledge of planners, and is predicated on the fundamental unknowability of much of economic life. Sometimes we forget that, but it's very clear. The other thing about the planner, and I guess I want to focus on this, is the way in which the planner purported to speak and act on behalf of the social body, on behalf of public or collective values, and in doing so, imposing a single set of values upon the collective. And neoliberalism represented a partial rejection of a certain social style of collective politics in which government purported to intervene in markets for and on behalf of the social body in furtherance of social values. And this seemed to the neoliberals, and I'm sort of saying the neoliberals as if that's sort of obvious. That's a way of talking. Let's not get too hung up on that. This seemed to entail unacceptable mystifications. Who gets to speak on behalf of the social? How do we know they're not dressing up their own parochial views as those of the social body? I mean, this is a sort of a pretty standard critique now, just as much heard on the left or the right. So this is very standard. In what sense does it even make sense to speak of social values when value is an irreducibly subjective thing? As Slobodian has most recently observed, that skepticism of social value and of the whole style of politics organized around the construction and speaking on behalf of social value went along with a skepticism of democratic politics, or at least the style of democratic politics of that era, as a way of collectively resolving the problem of value within a given community. And William Davies captures this element of neoliberalism as the pursuit. So he thinks neoliberalism, or in fact neoliberalization, is the pursuit of the disenchantment of politics. The disenchantment of politics. And what that meant was that neoliberalism was associated with the development of a huge variety, an incredibly creative variety, actually, of new tools of economic management which didn't work explicitly through mystifying invocations of social value. In fact, actively sought to eradicate that from the language of economic management. This new toolkit was extremely diverse, and I'm going to mention 3 of the tools in a moment. But the new techniques had in common was that they avoided, bracketed, obscured, marginalized, narrowed, or somehow set to one side questions of collective value within the conduct of economic governance. So when in the rest of the next half an hour or whatever, I refer to neoliberal economic governance as being characterized by a politics of no value, that's what I mean. Obviously, it's a fantasy. But the point is that it's a set of techniques for governing the economy which actively seeks to avoid, bracket, it always fails, but actively seeks to avoid, bracket, etc., questions of collective value. It's organized around that fantasy. So putting those 2 things together, what you get is what is the neoliberal for me in this talk? A form of economic governance oriented towards the construction of legal infrastructures for competitive markets, especially global markets, coupled with a new set of techniques for pursuing that aim, which work by actively displacing questions of collective value from the practice of economic governance. That's there we are. That's the starting point for neoliberalism. And so you can see that's a little bit different from neoliberalism as the Washington Consensus, being propagated around the world and transplanted. Right. Next stage. What did that toolbox look like at the global level? Very complicated, but I want to say there are 3 main things. 1, global economic governance through this period very often works through the mobilization of new bodies of technical expertise. So during this period, you get the valorization of institutional expertise, by which I mean expertise about the proper design of market institutions which treat that question as a matter of optimization and a matter of technical determination. So the Washington Consensus is in fact an example of that sort of expertise, a set of technical ideas about how to construct and govern markets. But more generally, you get a set of new evaluative techniques of economic governance. Economic analysis of law emerges around this time, comparative studies of economic governance in a new institutionalist vein. This is another thing that emerges at this time. Metrics of institutional quality, think the World Bank's worldwide governance indicators. What you're getting is a set of technologies for evaluating market institutions. Also, I'm thinking of regulatory expertise, by which I mean 2 different things. 1, food safety expertise, you get your food safety science and you have your regulatory experts, and this gets internationalized through the codex, and et cetera, et cetera. But also I have in mind the sort of cross-sectoral expertise, the new domain of regulatory policy, which there's a very interesting story that I've written a paper on and then put it to one side and never published yet, about the emergence of best regulatory practice as a generic body of expertise, which is transplantable to different different sectoral areas. Anyway, so what you get is a new marshalling of scientific expertise, expert peer review through these international bodies. You get the WTO requiring for the SPS measures to be based on scientific evidence, et cetera, et cetera. Okay, so the technical bodies of expertise about how regulation of market institutions ought to be designed. 2. The second part of the toolbox was the heavy reliance on the internationalization of rules of administrative procedure to discipline the new regulatory interventions by the state. And I think this is the most familiar bit of the story for international economic lawyers. So what I'm talking about here is the development of new international legal rules or their reinterpretation of old ones, which sought to enable the emergence of global markets by limiting arbitrary state interference in flows of global trade. What does that mean? That means regulatory measures, investment over trade, which affect trade and investment, were subject to proportionality review, least trade restrictive means test, transparency requirements, notice and comment requirements, norms of procedural fairness, rules against arbitrary discrimination, etc., etc. Many of those legal technologies had been developed in domestic jurisdictions for decades. Now they are in, and of course, nod to Benedict Kingsbury in global administrative law, obviously, but what's happening now during these decades is that they are being internationalized as a global technology for disciplining the regulatory state. And notice how that technique just is also structured by a fantasy of no value. The use of administrative procedure here is a disciplining device which is implicitly justified according to a substance procedure distinction, according to which the substance of regulation is still decided elsewhere, not globally, but rather it's just the procedural framework within that substance, within which those substantive decisions are taken. And of course, one can critique that distinction. I'm just saying that's an orienting fantasy. Third element of the toolbox that I'm giving you, three elements of the toolbox. This is the third one, and then I'll give you an example of how it all comes together. This third element of the toolbox is named less often, and it might be less well understood. It's a big part of the new book that I'm almost finishing. So we'll see. I'm testing it out a little bit. So the formations of global economic governance which emerged at this time didn't just set rules and establish standards and construct market institutions for global markets. They also created an environment in which those market institutions, global regulatory infrastructures, were made subject to ongoing reform and competitive contestation within certain structured limits. It was not just that this was a period in which the legal infrastructures for global markets were made, but also that these illegal infrastructures were made amenable to recomposition again and again. How so? Look, I'm just going to throw a few things at you, and they will feel a bit disconnected, but I'm going to give you an example in a moment. So at the most general level, in some obvious way, the new mobility of capital established conditions in which states began to compete with one another to attract capital and investment, in significant part, not only of course, but in part on the basis of their domestic institutions. Or think how, in so many different sectors, a condition of entry into global markets for your industry, I mean, whether it's cars or pharmaceuticals or agri-food or whatever, a condition of entry is the upgrading and modernization of your quality infrastructure and risk management infrastructures. Think of the increasing use of private standard setting initiatives or the emergence of large auditing and certification firms. Think of, just to explain my reference to those, that's a way in which, I'm thinking here also of the way in which legal infrastructures of markets are reconceptualized as services delivered in a commercial manner by firms, right? So think of private standard setting, think of auditing and certification. Think also in the financial services field of, this is exactly a period of the 80s and 90s when stock exchanges are, trading platforms are reconstituted as corporate entities, as private commercial entities in competition with one another. In effect, offering alternative and competing marketplaces with distinct rules of the game operative in each. So you can get a sense. And also, I in this larger picture, I also throw in new ideas associated with this body of expertise called regulatory policy, which emphasize the need for regulatory agility and adaptability, and seeks to harness actively certain forms of regulatory competition in the service of innovation, right? So it's also a particular mindset and way of approaching regulation, which emphasizes iterative review. Okay. So those are the three core elements of the neoliberal toolkit for creating legal infrastructures for global markets. All of them are oriented by a fantasy of no value in distinctive ways. Technical expertise displaces or brackets questions of value. Procedural administrative rules assert that those matters of value are determined elsewhere. This third toolkit about making legal infrastructures amenable to change, that's a way of bracketing questions of value because it keeps substantive choices about regulatory infrastructures always unsettled, open to revision, in play, never subject to final resolution, right? So you never speak really on behalf of the social. All of those three need to be considered together, and probably with much more, to get a picture of the kinds of markets which are constituted as a result. Right. So now let me give you an example of that, because that's a whole bunch of stuff. Yeah.
The regulatory disciplines, how do they relate to collective value? I think you didn't.
So the third one is, so that when you say regulatory disciplines, so there's two ways in which they enter. If what you mean by that, wait, what do you mean by
I want you to, so you went on how the three versions, three tools, how they reflect on collective value, but you mentioned just first and third. The second one on regulatory disciplines, which goes a little bit
procedural disciplines.
Because they actually constrain states to kind of, if in the first the value is done elsewhere, then if the states are constrained, so there is the value anyway. So
no, I understand that, but I think, and we should come back to this but let me just give a very quick answer, which may be unsatisfying. But so I have a lot to say about the model of international rules like this constraining states. I don't want to say it's wrong. I just want to complicate it in many, many ways. But one of the ways would be, well, but the specific point I'm making now is that is a way of disciplining the state, which, sorry for the way of talking, but which operates according to a fantasy that it is purely procedure. By which, okay, you get to determine what risks relating to industrial agricultural technologies you're willing to, genetic modification. You just need to make sure there's scientific basis. You need to make sure that it's consistent. You need to, et cetera, et cetera. But you decide your appropriate level of protection. So now what counts as substantive, what counts as procedure, that's always immensely, that's where the politics is in a way. But do you see what I mean? Like the orientation is, yeah. Okay, cool. But we can come back to that because I
wanted to have my notes in order.
Yeah, I understand. Yeah, I know. You can tell I'm trying to create easy notes by the way I'm right. So now we have a second section, another section.
Your notes afterwards.
Yeah. Right. Agri-food. I'm going to just talk a little bit about how those three things. So those three technologies are combined in various different ways and for various different effects, depending on the sector you look at. This is not a monocausal or simple story. That's why I'm just going to focus on one sector now, very quickly, just to give you an illustration of what I'm talking about. Agri-food, one sector, one big sector. Right. It's a complicated story. Let me break it down to what, for now, is its bare essentials. Right. I'm going to start by saying this. There were three key pressures. I'm starting in roughly the 1980s. I'm drawing here on especially Friedman and McMichael, but also Stefano Ponti, like the sort of political economy, second food regime theorists, but also your convention theorists. Right, so three key pressures driving and shaping the development of global regulatory governance in the agri-food sector in the 80s and 90s. One, this is the bit as trade lawyers we're very comfortable with. Food safety regulation increasingly becomes the subject of major trade disputes, especially transatlantically. We all know beef hormones, but there are many more. Disputes of that sort focus attentions on differences of approach to food safety regulation and drive a range of international initiatives to try to align approaches to food safety regulation, more or less successful. Second, strong pressures from a variety of different interests to liberalize agri-food markets comes from many directions. One direction was actually a source of developing countries who had just undertaken process of institutional reform in the name of structural adjustment, seeking to build new export markets in fruits, vegetables, fish, flowers, etc. Obviously, that new push for liberalisation was significantly tempered by enduring demands from some northern producers for stability and protection, which was the orienting idea of the post-World War II system. Also structured that, yes, general demand for liberalisation, but also ferocious and bitter mutual competition between northern producers in the US and the EU for new markets. Third key driver, and this I really want to focus, well, it's a very important part of the story. Major supermarket chains, your Carrefours of the world, Tesco's, your Aholds, your, et cetera, Walmarts, emerge as very powerful actors in global supply chains and begin to adopt new competitive strategies. What are those new competitive strategies? Well, yes, of course, they invest in transnational supply chains with diverse and flexible sources of supply, which can provide a wide range of fresh produce to northern consumers year round. But also, and here, little asterisks in your notes, it meant engaging in more quality competition as opposed to price-based competition, including appealing to consumers in part on the basis of conditions of production along the length of the supply chain. Think of the organic food movement from the 60s, but gradually expanding fair trade, but its sustainability and the widening dimensions of sustainability over time. This form of quality competition proved to be lucrative for retail distribution chains and also separately broadly suited the interests of certain northern agri-food producers who felt themselves better on the terrain of quality rather than price. Okay. So there's my stylized three pushes in response to which global regulatory infrastructures emerged. So what legal infrastructures emerged? First, a huge new ecosystem of private standards and certification systems relating to food quality. Tesco's, Nature's Choice, Fair Trade, Global Gap, et cetera, et cetera. The dynamics of this field are complex, but broadly speaking, this is a terrain of competition between standard schemes, not just competition on the basis of quality, but competition over what quality means, how it should be measured, what aspects of quality consumers should pay attention to, and so on. It's one of the main ways in which this dynamic of quality competition played out in the agri-food sector. Crucially, this ecosystem of competitive standard setting, just notice how this is a form of regulation, which is where competition is internalized into regulation and quality measurement itself, is enabled by a larger regulatory infrastructure which provides its conditions of possibility and shapes dynamics of competition within it. So, for example, you get international standards developed about how to go about certification, about what accreditation looks like, about how standard setting should occur, like so meta standards. They help to assure credibility in that marketplace, while at the same time keeping open the possibility of competition. At the same time, northern regulators, the regulators in major northern markets supported this ecosystem in a number of ways. They developed hybrid regimes of co-regulation which distributed certain regulatory tasks to this ecosystem. They actively, many of you will know about this, they actively resisted attempts by developing countries to discipline private standards by the extension of WTO law and other international disciplines to them. And for a long time, they refrained from setting mandatory rules which would limit that domain of quality competition between private market participants. So that's part of what I mean. I'm still going with this story, but just that part of what I mean when I say that global economic governance created and maintained ordered spaces for contestation over market infrastructures. That's only part of the story. Here's another part of the story. Attempts to promote substantive regulatory convergence in the agri-food sector through expert-defined, science-oriented international standards. Codex in the area of food safety, and of course the WTO through its SPS agreement backs those international standards by strongly encouraging, in some ways requiring, in some ways encouraging WTO members to use them as the basis of their SPS measures. So where did those technical, so that's my first element of the toolbox, there's the technical standardization. Where did those efforts lead? Well, I think there's two parts to this story. divide it first into rules about new techniques of industrial agriculture, the use of hormones in the production of beef, genetic modification, but also which pesticides can you use, et cetera, right? So new technologies of industrial agriculture. Here, substantive convergence proves, in my view, elusive. Sometimes successful, but broadly speaking, elusive. Consensus proves very hard to come by, implementation even harder to ensure. When attempts were made to litigate these issues at the WTO, sort of enforce international standards before the WTO dispute settlement system, broadly speaking, that system tended to fall back on the second toolbox, norms of administrative procedure, the need for adequate risk assessment, transparency requirements, no undue delay in procedures, et cetera. They're the main source of discipline. And they do provide some meaningful discipline. There is some constraint there, but also, frankly, it leaves in place considerable room for the strategic use of regulatory policy as an indirect instrument to shape competitive conditions in global agri-food markets. And I mean that neutrally. I'm not saying, look, I found something. What I mean by that is it could be, let me just promote my producers to the expense of others, or it could be, let me try and promote sustainable agriculture, et cetera. I'm just saying it leaves open considerable room for the strategic use of regulatory policy to shape markets. The European Union has famously adopted this as part of its strategy for the agri-food sector, using its market power to promote the adoption of strict sustainability standards throughout global supply chains servicing the European market. Okay, so I said technical standardization had two halves to the story. That's the substantive that's the sort of substantive rules around technologies of industrial agriculture. But there's another story which actually we don't tell as often, though it's very well known. But technical standardization proved tremendously effective in this other area in matters of process and protocol. What I mean by that is the development of international standards regarding the administration of inspection and control systems, methodologies for risk assessment, protocols for risk management, the HACCP system for risk identification and dealing, right? It's not so many international standards. When you look at what Codex has produced, what the IPPC has produced, what the World Organization for Animal Health has produced, many of the standards which have been developed since the 1990s are standards of that kind, many of them. But it's not just that you get lots of international standards, it's also that you get regulatory architectures really effectively designed to promote their adoption. So you get domestic food safety systems imposing liability for the first time on importers of food to ensure the safety of their food throughout their supply chain. What does that do? That means the importers, that your big retail distribution chains, are incentivized and do implement these new risk management protocols throughout the supply chains. In addition, you get a new way of implementing equivalence arrangements in the sensitive sectors like beef and chicken and poultry and fish and seafood and so on, where you say, if you want to export beef to our market, you need to be, your inspection and control systems need to be equivalent to ours. And that in practice means adopt a HACCP system, adopt, et cetera, et cetera. The risk management protocols and procedures need to be up to a global standard. So the story in this half is largely one of global alignment at the level of risk and quality management systems, not so much rules about which pesticides can you use, risk results. And that architecture provides conditions of possibility for competitive strategies. Not going to go into. So one of the key points I wanted, so that's my story about agri-food. And one of the key points I want to draw out about that is that look at how those techniques of global regulatory governance worked together to create an enabling environment for strategies of infrastructural competition. In other words, it is a regulatory structure which enables various actors to compete in markets by shaping regulatory infrastructures to their advantage. This architecture provides the conditions of possibility for such strategies, creates space for them to be pursued. It offers legal instruments for those strategies to be pursued. It defines their stakes. It enrolls and motivates various actors to engage in them. It also provides limits to them and boundaries to them. It's always structured competition. We can think of this if we've entered terrain which is a bit unfamiliar. Some of you might find it helpful if I talk in terms of affordances. We can think of this in terms of an institutional affordance, which we usually talk about in terms of technology. So in the same way that social media, the technology of social media elicits certain behaviors from us, doom scrolling, rage posting, all the rest, because of the affordances of the technology itself. That's what I'm arguing about this institutional infrastructure. It enrolls actors in various processes of competitive contestation over the rules of the game. And Michel Callan, Alison Loconto, and Lawrence Bush have all argued that neoliberal globalization was characterized by the emergence of what they call highly reflexive markets. And what they mean by that are market orders in which actors in those markets explicitly question the way they are organized and then try to conceive and establish new rules for the game iteratively. That's what they mean by reflexive markets. And the suggestion I'm making here is that reflexive market, these kinds of reflexive markets were brought into being, shaped and made possible by a specific international legal infrastructure and a specific set of legal devices. And I'm suggesting that those reflexive market forms are both the product of and help to sustain the vanishing of a different imaginary in which the design of market institutions is a space for the expression and contestation and enactment of collective value. It's very different. It's a very, very different way of producing a market infrastructure. Wait, no, sorry. No. Sorry, there's a little more. I apologize, but there's only a small amount. Have I got time? Yeah. Okay. So actually, to be honest, in many venues, I would stop it there, but I kind of wanted to speak to those people who would say to me, like, yeah, okay, great, but like Trump, like what's happening now? This whole thing is falling apart. So that's what I want to say. Why it's interesting to think about this now. So two thoughts on why this is important now, just as this structure of global economic governance appears to be crumbling around us. What purchase does this story give us on current events, and how might it help us to respond to them? Okay, first. So when I look around at what's happening in the global economic order now, a lot of what I see, I'm not trying to create a single story here, but a lot of what I see looks like a pathological intensification of dynamics of infrastructural competition. That is to say, predatory competitive strategies which seek to dominate through control of market infrastructures. It's true in the realm of economic statecraft and in global markets. So within economic statecraft, you see competition increasingly taking place over control of infrastructural choke points. I developed this before the Strait of Hormuz, et cetera, et cetera. But, think of the Panama Canal, think of Greenland, and energy infrastructure. So choke points in energy infrastructure. Same is true of supply chain infrastructures, whether this is the weaponization of supply chain dependencies through export controls or the leveraging of architectures of supply chain governance in the pursuit of global sustainability. Financial infrastructures have for decades been a tool for the global projection of power through sanctions. But I think it's also true of legal infrastructures. Much of the current US administration's international economic policy can be understood as a strategy of leveraging its economic might to reshape the fundamental legal architecture of the post-Cold War order in its favor. Looking at the bilateral trade deals which the US administration has negotiated or partly negotiated, these have become many things, but they are partly spaces through which the US is seeking to coercively shape and limit and constrain and slow down the development of global regulatory frameworks around AI, digital platforms, sustainability, cryptocurrency, corporate taxation, etc. There's a way in which it's sort of regulatory strategization on steroids. And a similar story of infrastructural competition can be told at the firm level. Platform companies build walled gardens which bring buyers and sellers together in an infrastructural environment that they control, and they extract rents from the control of the infrastructure and the dependencies that creates. Tech titans are racing for control of global digital infrastructures, data centers, satellite constellations, AI models, with a view to profiting in the future off the dependencies they create. So I'm not suggesting that those behaviors and strategies are unique to the current moment, hardly. And one instinctive response to that argument will be, well, hold on, Andrew, contestation over legal infrastructures of markets is like natural. That's just what happens. In fact, it's just a fact which requires no explanation. And that's it. You know, it's just endemic to all markets. And at some level, yes, it is, yes. But to treat that as purely natural, as just something that happens, is also a mystification, which I would argue is the same, sort of a parallel or mirror image mystification of the natural competition of markets, right? Like markets just exist. We all compete with one another. That's just what we do, right? My suggestion is that we don't naturalize this kind of contestation. I would say that the particular strategies which are available, competitive strategies, are legally constituted, and that the stage has been set for the sort of competitive strategies we see now by 4 decades of neoliberal global economic governance. And that suggests the need for a new object of international legal analysis and critique, namely to investigate contemporary forms of predatory infrastructural competition and to ask how they have been internationally constituted and made available through international law. How do existing configurations of global economic governance provide their conditions of possibility? How do the existing governance structures operate to cement the link between economic power and control over legal infrastructures? And a corollary of that task is analytically, I'll be interested, maybe we can talk about this afterwards. Analytically, I think we need to do a lot more. We need to do better to distinguish between better and worse, harmful and beneficial forms of contestation over the rules of markets. Because sometimes it's okay. It's good. It's what we want to do. It's democratic. And sometimes it's predatory. There are better and worse forms of reflexive practice, and we need to have better analytical and conceptual tools to distinguish between differently constituted reflexive markets and the different forms and practices of reflexivity that are made available within them, and to whom they are made available. How is the capacity and ability to act reflexively distributed within? And concretely, for those of you who very justifiably want something a bit more, something to hold on to, that might mean naming bad forms of infrastructural competition and building the necessary normative infrastructures to remove or reduce them. New rules on economic coercion, or rules on free and equitable access to critical market infrastructures. Maybe extend global standards of responsible business conduct to matters of predation and coercion, or undermining democratic institutions. Maybe you extend existing experiments, which you currently see in trade sustainable development chapters in free trade agreements, which prohibit competition based on lowering or failing to enforce your labor and environmental standards. More generally, you're looking for ways to organize competition over global regulatory infrastructures which break the link between economic power, regulatory influence, and infrastructural power. Right, that was my first comment. Second one is this, and it's I think a condition of this is the re-enchantment of global economic governance. So I argued that the neoliberal period constituted a disenchantment of market governance, a refusal of styles of governance which purport to speak and act for and on behalf of a social body. And I think as international lawyers, we live with the legacies of that process of disenchantment. The tools and techniques that we have available to us, our ways of thinking and talking, the limits we place on ourselves have been shaped by its politics of no value. I think we've adopted that disenchanted style and its pathological avoidance of matters of collective value. And I think that's true also of some of our critical vocabularies. And I think this leaves us ill-equipped to respond to the current moment. And I love Ezra Klein right now. And Ezra Klein has observed, and mostly, so let's also talk about that, but mostly, and he talks mostly in relation to domestic US politics. So I think the observation is a general one. He says contemporary events pose the central question of who and what the global economy is for. Yes. As such, they demand a politics of collective value. And he laments, for the most part, liberal internationalists have responded in terms of the need to respect the rules-based order, to maintain our commitment to existing institutions as if these were ends in ourselves. And of course, he notes, and he's right, that's an important part of the response. Yes, of course it is. But it's not a good enough answer. And when that's our answer, people look in other directions for a politics of value, most visibly in the dangerous politics of flags, ethno-nationalism, and faith. And I think he's largely right about that. I think his observations are relevant also to international lawyers. I think we too find ourselves articulating our objection to the current moment as a generalized anxiety about the collapse of the rules-based order, and we articulate our criticisms as a lack of respect for rules and existing institutions. But our habits of thought and our ways of speaking make it hard to actively open space for direct discussion about what the global economy is for and what economic outcomes we think are harmful and beneficial. And we see this even in technical discussions. So, think about WTO reform, the need for balance in the global trading system, about addressing overcapacity, harmful forms of competition. Very quickly, we run out of a language to specify what we mean exactly by overcapacity or harmful competition. Or we're beset by an anxiety that if we do that, we're imposing a single set of values on a properly plural global economy. But building a better global economy requires us to name the harms that the existing global economy has created. And creating a more pluralist and institutionally open economic order requires us to specify enabling norms of responsible conduct which allow for that. And they are inescapably moral questions. So I think one of the tasks for international lawyers is to rid ourselves of our excessive attachment to a disenchanted style and aesthetic and technologies of global governance, which have become so prevalent in our field for the last 40 years. We need a new re-enchanted toolbox of global economic governance, which is not haunted by the spectre of the long-gone planner, and instead provides some kind of space for the question of how global markets ought to be arranged in the morally charged languages of fairness, balance, abundance, planetary responsibility, and so on. Of course, just to anticipate something, of course, that's going to look very different at the global level as compared to the national level. Everyone understands there's not going to be a single answer to those questions, and nor should there be. But we can imagine better and worse ways of relating to one another, better and worse ways of enacting our disagreements over matters of market governance, better and worse modes of contestation over global legal infrastructure. And that seems a worthy goal for international lawyers. So thank you very much for your attention.